When most of us picture a lawyer in a courtroom, we tend to imagine this like absolute gladiator.
Oh, yeah. The classic Hollywood bulldog.
Right, someone who is just fighting tooth and nail, using every trick in the book, every loophole they can possibly find, just to win for their client. It's this very aggressive, binary image. You win or you lose, and the lawyer is, your ultimate weapon.
It's so ingrained in us, that archetype of the brilliant, relentless attorney who will do absolutely anything to secure the verdict.
But when you actually peek behind the curtain at the training materials, which is what we're doing today, the very documents used to teach and test solicitors on their professional conduct, you realize that picture is almost completely wrong.
Yeah, it's a lot more complicated than the movies make it look.
It really is. So welcome to today's deep dive. We are taking a fascinating stack of these legal rule books today to decode the hidden, incredibly high-stakes ethical tightrope that lawyers actually walk. And our mission is to show you that being a lawyer isn't just about arguing to win.
It's far more complex than that. I mean, as you go through these scenarios, every single ethical dilemma a solicitor faces essentially boils down to one simple, yet surprisingly difficult question.
Which is?
Who does the solicitor owe their duty to in this specific situation? Is it the client sitting across from them, or is it the court?
Right, the ultimate tug of war.
Exactly.
Yeah.
And those two duties are frequently, pulling in completely opposite directions.
Well, let's unpack this, because by the end of this deep dive, you are going to see the legal profession in a completely new light. So let's start right where the stakes are highest, where the lights are brightest, the courtroom.
The arena.
Yeah, the arena where that tug of war between duty to the client and duty to the court really gets intense. Let's look at witnesses, for example. Say I'm a solicitor, and my client's case hinges on a specific witness showing up and giving, great testimony. Can I just pay them to be there?
The short answer is yes, but the ethical tripwires are everywhere.
Really? So I can literally hand a witness cash?
Well, you can pay them, but only under strictly limited circumstances to cover their actual inconveniences. What you absolutely cannot do is pay a witness to give favorable evidence or, promise them a bonus if your client wins the case.
Oh, I see.
Yeah, there's no such thing as a success fee for a witness.
Okay, so if I try to put that into a business context, it's kind of like the difference between reimbursing an employee for a business lunch versus paying them a massive sales commission.
That's a really good way to look at it.
Right, so reimbursing a witness for their travel costs, maybe a hotel room, or paying them for the genuine earnings they lost because they had to take the day off work,
Right.
that's just covering their out-of-pocket expenses.
Yeah, no.
That's the business lunch.
Exactly.
But paying them a commission for a victorious verdict, that completely corrupts the interaction.
That analogy hits the nail on the head. Because if we look at the broader mechanics of the justice system, the court relies entirely on the integrity of the evidence presented.
Right, the truth.
Right. If witnesses could be paid on a sliding scale based on the outcome of a case, the judge or the jury would constantly be wondering if the testimony is actually the truth, or just, a performance for a bonus check waiting in the hallway.
Oh, wow. Yeah, that makes sense. The court needs honest evidence, not evidence that has been bought and paid for on commission.
Exactly.
Okay, so we've established you can't buy evidence to help your client. But I found this next part of the training materials completely counterintuitive. It's regarding how a lawyer handles past case law, like the precedents, when they are standing in front of a judge.
Oh, the disclosure dilemma. Yeah, this tends to shock people who are new to legal ethics.
It shocked me. Okay, so imagine I'm the lawyer. I'm in court, arguing my heart out. And I know there is a specific legal authority, a past case, that completely torpedoes my client's argument.
Just ruins your whole case.
Right. It is terrible for us. But, miraculously, the opposing lawyer is incompetent and forgets to mention it. It's my lucky day, right? And I just keep my mouth shut and take the win.
If you do that, you are actively breaching your professional duty.
Wait, seriously? I have to tell the judge about the law that destroys my own case.
You do. As a solicitor, you are legally obligated to inform the court about any relevant legal authorities that are likely to have a material effect on the outcome of the case.
Well, why?
Well, by material effect, we mean a precedent that could legitimately change the judge's ruling, not just some minor typo in a footnote. You have to bring it up, even if the other side has missed it.
Okay, but let me argue from a purely contractual standpoint for a second. If I hire a plumber, they fix my pipes. They don't point out that my neighbor has better pipes. I'm paying them for a service to benefit me.
Right.
So if I'm paying a lawyer to win, and they hand the judge the very weapon the other side needs to defeat me, Haven't they betrayed that transaction?
I get that logic, but that assumes the legal system is purely a private marketplace. And it isn't. A solicitor is not just a hired gun for private transactions, they are an officer of the court.
An officer of the court.
Yes. Protecting the proper administration of justice always comes before winning at all costs. The judge relies on the lawyers to map out the full, accurate landscape of the law so they can make a correct, lawful decision.
Oh, I see.
So if you hide a relevant law, you are effectively tricking the judge into making an unlawful decision.
Wow. So it's not a game of hide and seek. You actually have to help the referee the game, even if it costs your team the match.
Because if the referees can't trust the players to follow the foundational rules, the entire sport collapses. The justice system only functions if judges can trust lawyers implicitly to provide the whole picture.
That is wild. I mean, it makes sense when we're talking about strict legal precedents, but the tension ramps up significantly when we introduce the most unpredictable variable of all, human behavior.
Oh, absolutely. That's where it gets really messy.
Right, because we know a solicitor can't hide bad law from the judge, but what happens when the client tries to hide the facts? Let's set the scene with the mistaken judge scenario from the sources.
Oh, this happens in courtrooms far more often than people realize.
Okay, so we're halfway through a hearing. The judge is summarizing the situation, and they make a factual mistake. Not a legal mistake, a factual one. Let's say they misunderstand my client's income, and this mistake heavily favors my client.
Okay, yep.
My client hears it, realizes the judge messed up, and just stays completely silent to pocket the advantage. And as their solicitor, I realize exactly what is happening.
The ethical alarm bell should be ringing loudly for the solicitor in that moment.
But why, though? If I'm the lawyer, my mandate is to protect my client. The judge is paid to get the facts right. Why is it my problem to fix the judge's typo, especially when fixing it cost my client money?
Because the distinction here is between passive advocacy and active deception. A solicitor cannot knowingly allow the court to proceed on false information.
Even if the judge is the one who made the mistake.
Even then, if you realize the court is operating on a factual error and you let the proceedings continue based on that error, you transition from being an advocate to being complicit in misleading the court.
Man, so what's the actual protocol? What do I do in that room? Do I just stand up, point at my client, and yell, "Objection, we're lying by omission"?
No. You still owe a strict duty of confidentiality to your client. You don't just throw them under the bus in open court.
Okay, thank goodness.
Yeah, what you do is you ask for a brief recess. You take your client into a private consultation room, and this is where the real psychological friction of the job happens. You have to convince them to give up a winning lottery ticket.
That has to be an incredibly tense conversation. How do you actually persuade them to just give up that advantage?
You lay out the stark reality of risk management. You explain that if the court discovers the deception later, and they usually do, the consequences are severe. The client could face perjury charges. The entire case could be thrown out.
Right, the blowback.
Exactly. And you explain that as an officer of the court, you cannot participate in a fraud. You try to get them to see that correcting the record now is the only viable long-term strategy.
And if they look at me and say, "No way, the judge messed up, I'm taking the win, keep your mouth shut," what then?
Then you must withdraw from the case entirely.
Really? You just walk away?
You cannot continue to represent someone if it means helping them deceive the court. You just have to walk away.
Wow. Which brings us to the absolute peak of this tension, the classic law school exam scenario. The criminal confession.
Oh, the big one.
Right. I'm a defense attorney. My client is on trial for a serious crime. We're sitting in that same private consultation room, and they look me dead in the eye and confess. They say, "I committed the offense." Do I have to drop them right then and there?
You don't, and this is a very delicate, crucial distinction. Everyone, regardless of what they have admitted to in private, is entitled to legal representation in a fair trial. You can still represent them.
But wait, we just established I cannot mislead the court. If I know they are guilty, how can I walk into that courtroom and plead not guilty? Isn't that a direct lie to the judge?
Well, pleading not guilty in a legal sense doesn't mean I didn't do it. No, it is a procedural mechanism that basically means I am requiring the state to prove its case against me beyond a reasonable doubt. So, as their solicitor, you can aggressively challenge the prosecution's evidence.
How does that actually work in practice, though? If I know they did it, what does cross-examining a witness even sound like?
You focus on the reliability of the state's case. You can ask a police officer, "Isn't it true the alley was completely dark?" You couldn't see the suspect's face clearly, could you?
Oh, I see.
Yeah, you can point out flaws in the forensic investigation. You are holding the state to its heavy burden of proof.
Okay, so I can poke holes in the prosecution, but where is the line I can't cross?
You cannot introduce a lie. If your client has admitted guilt to you privately, they cannot take the witness stand and claim they are innocent.
Ah.
Right. You cannot let them testify that they were out of town when the crime happened or point the finger at someone else. You can test the truth of the prosecution, but you cannot actively build a false narrative.
And if they insist on taking the stand?
If the client insists on taking the stand to commit perjury, you draw a line and walk away.
Got it. So a solicitor can defend someone who is guilty, but they can never help someone deceive the court. It's a razor-thin line.
It really is.
But, that tension between truth and advocacy assumes you actually know who you are advocating for. When you dive deeper into these training materials, figuring out who the real client is turns out to be a massive ethical minefield on its own.
Oh, absolutely. Taking instructions from a client seems like the most straightforward part of the job, but it is fraught with risk, particularly when vulnerabilities are involved.
Let's look at a scenario that probably happens in local law practices every single day. The elderly client.
A very common one, yeah.
Right. So an adult child walks into the solicitor's office and says, "My mom wants to update her will and sell her house. She's quite frail. She isn't well enough to come into town today, so I'll just tell you what she wants to do and we can get the paperwork started." As a lawyer, can I just say, "Great, let's draft it up"?
Absolutely not. You cannot accept those instructions at face value. The solicitor's client in this scenario is the mother, not the adult child sitting in front of them.
Right, because that raises massive red flags, doesn't it?
Huge red flags regarding coercion and undue influence. How does the solicitor know the adult child is truly conveying the mother's wishes? How do they know the child isn't pressuring her or acting entirely in their own financial interest?
Right. If I just draft a new will, giving everything to the child based purely on what the child tells me, I might be actively facilitating financial abuse.
Precisely.
So how does a lawyer investigate that without being, overly accusatory to the kid?
The solicitor has an affirmative duty to bypass the intermediary. They might insist on a private phone call with the mother, or ideally, visiting her at her home. Crucially, they must speak with her without the adult child present in the room.
To see what she actually wants.
Exactly. The solicitor is testing two things. First, does the mother have the mental capacity to understand these legal decisions? And second, through open-ended questioning, are they certain these instructions are genuinely coming from her own free will?
That makes total sense.
Yeah.
But what about a situation where it's not a parent and child, but two people who are clearly in a partnership, like joint clients?
Okay, like a married couple.
Yeah, a married couple selling their house. Do I really need to have a deep, probing conversation with both of them every time a mundane document needs to be signed? Can't one spouse just handle the logistics for the household?
Well, one person can handle the day-to-day logistics, yes, but only if both clients have given genuine, real, and informed consent for that arrangement.
Oh, so I can't just assume.
Right, you cannot just assume that because they are married, one speaks for the other. If a conflict of interest arises between them, say they decide to separate halfway through the house sale, the solicitor can't just keep taking instructions from one spouse and ignoring the other.
Wow. Okay, let's throw one more twist into this client identification puzzle, because this part of the material really highlights the nuance. The rogue power of attorney.
Oh, this is a tricky one.
Imagine a client is incapacitated, maybe with advanced dementia. They can no longer make decisions. But they previously set up a valid power of attorney, legally appointing someone else, let's call him the attorney, to make decisions for them.
Okay, standard procedure so far.
Right. So the attorney comes to me, the solicitor, and says, "I want to execute this transaction using my power of attorney." But I look at the transaction, and it is clearly, undeniably harmful to the incapacitated client. It drains their bank account for no apparent reason. Do I have to do it because the attorney has the legal paperwork?
No, you must refuse the transaction.
But the attorney has the legal authority. They are legally appointed by the state to give instructions.
They are appointed to give instructions, yes, but your duty as a solicitor remains firmly attached to the original client, the incapacitated person.
Ah, I see.
The attorney is merely a conduit. If the conduit is acting against the best interests of the actual client, you cannot blindly follow their orders just because the paperwork is stamped.
It's like someone holding the keys to a car. Just because you walk up holding the keys and you're sitting in the driver's seat doesn't mean you actually own the car.
Great analogy.
As a mechanic, My duty is to make sure the car itself is safe and well maintained for the actual owner. I'm not going to slash the tires just because the guy with the keys told me to. The duty is always to the owner, even if they aren't physically in the room.
That perfectly encapsulates the dynamic. The person speaking to you is not always the person you owe your professional duty to. You have to look past the immediate interaction and ask, who is actually going to suffer the consequences of this legal action?
It's so layered. But knowing exactly who the client is and keeping them from lying to the court assumes the lawyer actually knows what they are doing in the first place.
Which is not always a guarantee.
Yeah, right. Which brings us to a surprisingly strict standard in these rules. The baseline requirement of professional competence.
Competence is often misunderstood as simply possessing a law degree. But in the eyes of regulatory bodies, competence is highly specific, situational, and dynamic. It's not a blanket status you achieve once and keep forever.
The sources gave a stark example of this. Imagine I'm a lawyer who has spent the last 10 years entirely focused on commercial contracts. I sit at a desk, reviewing corporate mergers, reading the fine print on supply agreements.
Very specialized, very dry.
Exactly. Suddenly, a very wealthy, very desperate client phones me up. They are facing a massive, serious criminal fraud investigation, and the police interviews start tomorrow morning. They want me specifically to represent them. They're waving a blank check at me. Can I take the case?
You cannot, unless you genuinely have the knowledge and experience to provide competent representation within the extremely tight time frame available. You must refuse the job.
But what if I promise the client I'll stay up all night reading criminal procedure textbooks? I'm a smart lawyer. I know how to research.
Trying your best is not a defense against professional misconduct.
It's not.
No, the standard isn't effort. The standard is actual practical competence. Criminal fraud procedure involves entirely different stakes and rules compared to commercial contract law. If you make a procedural error during a police interview because you are out of your depth, your client could go to prison.
Oh, wow. Yeah.
Wanting to help isn't enough. If you cannot do the job properly, taking the case is an ethical breach. You have to recognize the boundaries of your own expertise.
It's a humbling requirement. You really have to put your ego aside.
Yeah.
But this competence isn't just about what's inside the lawyer's brain, is it? It's also about how that information is transmitted out of their brain and into the client's brain.
Exactly. Tailored communication is a massive pillar of professional competence. Knowing the law is entirely useless if you cannot explain it to the person whose life is affected by it.
So if you just sit there sounding like a walking legal dictionary, you aren't actually providing counsel.
Right. The solicitor must communicate in a way that that particular client understands. If you have a highly sophisticated corporate client, they might require a 50-page detailed written memo.
Sure.
But if you have an individual who isn't familiar with the legal system, they need plain English. If you have a client whose first language is in English, you might need to arrange a professional interpreter. If they have a visual impairment, you need accessible documents.
So you really have to adapt.
You do. True competence means ensuring the client comprehends their legal position well enough to make informed decisions about their own life.
But ensuring the client understands the law is only half the battle within a modern legal practice, isn't it? Because if a senior partner is relying on junior staff to translate and apply that law, a whole new ethical trap opens up regarding who is actually responsible.
Yes, this is the critical area of supervision. In any law firm, senior solicitors are strictly accountable for the people working under them. It is not just an administrative task, it is a profound professional responsibility.
The text gives an example of a senior solicitor who decides to take a 2-week vacation. They pack their bags, fly to a beach somewhere, and leave their junior trainees and paralegals back at the office working away. But they don't formally arrange for another senior lawyer to cover their supervision duties while they are gone.
And that failure is a clear breach of professional duty.
Really? Just going on vacation.
Because if those junior staff make a mistake while the senior lawyer is sipping cocktails on the beach, the senior lawyer is the one held accountable by the regulatory body.
So it's essentially this structural load-bearing wall, right? Like a chain of brain power.
That is exactly what it is, yeah. A chain of custody for legal liability.
Wow. Because it's not just about your own capacity to practice law. I mean, it's making sure your client understands it too, and guaranteeing that your junior staff are being actively guided by someone with actual experience.
Because a break in that chain of liability is dangerous. Good supervision protects the client from catastrophic errors, it protects the firm from malpractice suits, and ultimately, it protects the integrity of the justice system itself.
It's all connected.
It is. The system relies on layers of accountability. It extends to non-solicitor staff too, paralegals, legal assistants. The buck always stops with the qualified supervising solicitor.
Man, let's take a breath and zoom out for a second. When you look at all of this together, the incredible balancing act that solicitors have to perform every single day is staggering.
It really is a lot to carry.
They are reimbursing witnesses for their bus fare, but actively refusing to pay for favorable testimony. They are standing up in court and handing the judge the very legal precedent that ruins their own case, just to serve the higher cause of justice.
And they're aggressively defending people they privately know are guilty, while simultaneously ensuring those same clients don't tell a single lie on the stand.
And on top of all that, they are fiercely protecting vulnerable clients from the very family members who claim to speak for them.
It really reframes the profession, doesn't it? The next time you interact with a legal professional, you'll understand the invisible pressures weighing on them. They aren't just fighting to win. They are constantly navigating rigorous, sometimes conflicting ethical standards that dictate their every move.
They are officers of the court first and advocates second.
Exactly.
It completely changes the perspective. But as we wrap up, I want to leave you with a final thought to mull over, something that builds on all these rules but pushes them into the future. We just talked about competence and supervision, that chain of custody for legal liability. But as the legal world becomes increasingly reliant on artificial intelligence and instant automated communication, how are the definitions of competence and supervision going to evolve?
Oh, that's a whole other can of worms.
Yeah. Right. If a junior paralegal uses an AI program to draft a complex legal document while the senior partner is on that 2-week beach holiday, and the AI hallucinates a fake legal precedent, who is really supervising the administration of justice? Is AI a new type of junior employee, or is it a tool that requires entirely new ethical frameworks?
It's a huge question for the future of the industry.
As you think about that invisible ethical tightrope we've been exploring today, ask yourself, what happens to the balance when the lawyer is no longer the only intelligence holding the balancing pole? We'll leave you to ponder that.